Hello, everyone. Welcome to our new channel, Counterintel 419, Counterintelligence. This is a show that will focus on bringing you information that counters some of the myths and disinformation that is overwhelmingly disseminated throughout our community. We will also challenge some of the lies, propaganda, and omissions of truth and information that is critical to our history as well as what's going on today. This show is for educational purposes, and before we get started, make sure you share, like, and most of all, subscribe to this channel.
And recording to All right. This is Jerry Prim. I am one of the founders of The Solution, a Black community think tank headquartered here in Cleveland, Ohio. And today we have a special event with our Supreme Court Justice Michael P. Donnelly. I want to introduce the other gentlemen that are on that have their own respective podcasts and followings from around the state. I'm going to start out with Big Brother Russ Neal from Akron, Ohio.
Well, thank you, Brother Jerry. Name's Russ Neal. I'm a co-founder with my partner Darren Wright of Bring the Noise, Your Voice, Our Power, a platform that gives the community a chance to exercise their concerns. Served 14 years on Akron City Council, past president of National Black Caucus of local elected officials.
All righty. And let me go to your partner in justice, not partner in crime, but partner in justice. Your partner, big brother, Darren Wright.
Greetings. Darren L. Wright, Upscale Media Group, along with Russ Neal, doing Bring the Noise, Your Voice, Our Power. I always mess that up here. We do podcasts across the state. We also provide entertainment and do some other things with promoters. And also, my background from a political standpoint, I am a 5-time campaign manager that have put 2 different individuals on the Akron Public School Board. So we've been excited about keeping the motivation here as far as that. So that's it.
All righty. And in terms of introductions from the panelists, last but certainly not least, our big brother from Toledo, Ohio, big brother Albert Earl. Go ahead, tell us about you, big bro.
All right, I'm Albert Earl with the podcast Counterintelligence. We are actually, I would like to think of us as being a podcast that's nationwide because we are on many platforms. I'm also a board member here at the Frederick Douglass Center here in Toledo, the oldest African-American community center in the city. We are 106 years old. Been doing some great things in the past few years. I was board president, and we just had elections, and I'm finally back where I want to be, just as a regular board member.
That's right.
But I also do contractual work with several other organizations throughout the city. Most importantly, UMADOP Lucas County. I'm doing work with UMADOP Lucas County, and I've been working with Mr. Edwards since 2004, whether it's full-time employment or just contractual work.
I love UMADOP Lucas County. I love going up there with one drop, brothers. All righty. And Now, bringing on our Supreme Court Justice, Justice Michael P. Donnelly. I want to take a moment, if you would, just to make an introduction. I met Justice Donnelly a number of years ago. I always judge a person by how they treat you when they don't know who you are or don't know what you do. And and they treat you with dignity and respect. And I would say that, first of all, let me say that Justice Donnelly is a personal friend of mine. He has always treated me with dignity and respect, whether he thought that I was just handing out flyers on his campaign or a campaign strategist. It was the same thing. He and uh, I want to make sure that people across the state know that this is, I make no apologies for it. This is my man in this election. Uh, and he is not to be confused with somebody else who's been offensive to our community. And I really wanted him to come on today and make a presentation to show you not just what he not just talk. A lot of people talk, but to show you in action some things that he's done. You have to think about there are give or take 725 judges in the state. We've had a criminal justice system in the state for about 210 years, give or take. And he and God rest his soul, Ray Hadden, are the first judges to do what he's about to show you today. And additionally, let me let everybody know his presentation is going to last give or take about 30 minutes. And but never fear if you don't have the opportunity to watch it today. We're downloading and putting this on our respective YouTube channels so that you can watch it at your leisure. It's so important, and we want you to share this information, share this presentation with anybody and everybody in this state who cares or who even pretends like they care about criminal justice reform, as well as share it with our judicial candidates across the state as well. So without further ado, let me turn it on over to our Supreme Court Justice, Justice Michael P. Donnelly.
Thank you very much, Jerry. It's an honor to be here. I want to thank all the panelists as leaders in your community for inviting me and organizing this, and thank you for your friendship. I'm really looking forward to this discussion tonight with the viewers out there. A little background on me. My name is Mike Donnelly. I started my legal career. I was hired by the late great Stephanie Tubbs Jones, former Cuyahoga County prosecutor. I was one of her first hires as an assistant prosecutor. So I prosecuted for about 5 years. Then I went into civil litigation. I practiced about 12 years. And then I was fortunate to gain a seat on the Cuyahoga County Common Pleas Court. And I absolutely love the court. To be honest with everyone, I thought that I would retire a trial court judge. I loved bringing conflict to resolution in people's lives. And 9 of those years I served as a mental health court judge. So 25% of my felony docket was made up of people who suffer from schizophrenia, schizoaffective disorder, and developmentally disabled folks that found themselves in the criminal justice system. And I'm very proud of the fact we were able to keep the vast majority of those people out of the prison system, where they're often go in, become abused, mistreated, come out worse than before, and keep the community safe at the same time. So it taught me that there's better ways of doing things than incarcerating our way out of social problems. And I came to believe early on in my judicial career in what I call the greatest epiphany of my career. A lot of the criminal resolutions that take place in our system are not resolved by people exercising their constitutional right to go to trial, but they are resolved through plea bargains, negotiated plea bargains. And there's a big mystery with the public about plea bargains, and there's good reason for that. That's because most of these plea bargains get negotiated and forged in the back room with the judge, the prosecutor, and the defense lawyer, but not the accused, whose life may be profoundly affected about what is being discussed back there. And if there's a victim in the case, they aren't there either. And I began to question this process because I came to the conclusion, again, the greatest epiphany in my career, that no one should say anything in the back room, including the judge, that they wouldn't repeat verbatim on the record. So one day I said to my bailiff, hey, John, we're going to do things a little differently. We can have these same discussions back that we've been having back here, but we're going to do them on the record, where the court reporter is going to take down everything that is said. And that way, everybody that makes a representation, including myself, that may resolve the case, a promise to the defendant about what the consequences are, I will be held accountable for that. And 30 days down the road, I don't get, if I'm in a bad mood, I don't get to change my mind about that. So I'm going to show a PowerPoint to your viewers tonight that shows you what every practitioner that practices in Ohio criminal justice system has known for years. And we have not done nothing about it. But now we have the opportunity, but there are forces at work within our government that are trying to politicize the courts, and they are working against an opportunity that we have to correct something that has been going on every single day. And what I'm going to share with you, I'm going to prove to you that Ohio's sentencing laws, combined with the lack of data that exists in our system, make it such that our sentencing laws are programmed to produce racial disparity from courtroom to courtroom, all kinds of disparity, not just racial, but particularly racial disparity. They directly lead to the pipeline that has 50,000 individuals incarcerated, making us one of the largest populations of incarcerated individuals in the country. And I'm going to show you how that happens on a direct in this presentation that I'm about to give. And public confidence, I've always said, is threatened when people believe that their sentencing outcomes are not based on the rule of law, which requires proportionality, fairness, consistency among the judges, but are more tied to the individual proclivities of the judge that you're assigned to at your original hearing. That is when public confidence is threatened, but that's exactly the status quo that exists in the Ohio's broken criminal justice system, and we can fix it. So if I can share my screen at this time, I'm going to go to the PowerPoint presentation, and I'll make sure everybody can see this. Okay. So I was fortunate to gain a seat on the Ohio Supreme Court along with Justice Melody Stewart, who made history, becoming the first African-American female to ever be elected to the Ohio Supreme Court in 2018. And we both ran together, and at the time, we were told we had no chance of winning because the court was controlled by jurists that are supported by the Republican Party. I don't call them Republican jurists because judges are not supposed to be partisan. I've been on record since 2011 saying that if we're going to have an elected judiciary, we should have nonpartisan elections because our allegiance shouldn't be to any political party. Our allegiance, as expected by the citizens of this state, no matter what party they belong to, is to follow the law. That's what our oath is. We follow the laws of the state of Ohio and the federal laws and the U.S. Constitution and the Ohio Constitution. That's who our oath, the oath we take when all of us are elected. When politics infect the judiciary, we have problems. Okay. I put this photo just today into this PowerPoint presentation based on an experience I recently had down at the courthouse. I had a meeting with two other judges. I arrived early, so I took a seat on the bench at the old courthouse down on Lakeside Avenue in Cleveland. And this elderly gentleman and his wife approached me. He was appeared to be in his early 80s. And he asked me if I was a lawyer, and I figured he just wanted directions. And I said, I'm a judge, sir, but how can I help you? Do you need directions to somewhere in the building? And he pointed at this sign and he said, can you tell me what this means? And it's a quote by Aristotle. And it says, and the rule of the law is preferable to that of any individual. He goes, tell me what that means. And I said, well, what I think it means is in a democracy where we understand that we're always going to have differences in policy and we're always going to argue about what policies are best. The agreement has always been that once those policies are codified into law, we all agree to follow the law. That we can always work to change the law. And there's a lot of unjust laws that exist once they are codified that should be changed. And we should always, as Americans, work to change those laws. But in order for the democracy to move forward and us to live together peacefully, we follow the rule of law. And that is, you've always heard the slogan, justice is blind. Well, when partisan politics infect the judiciary, we've got serious problems. One of the laws that are in the books that we're going to be talking about tonight contains the overall purposes of felony sentencing in the state of Ohio. And it's codified in Ohio Revised Code 292911. And it directs every single judge to, at a sentencing hearing, to punish the offender for what they did, protect the community from future offenses from that offender, set that individual on a course towards rehabilitations, if that is possible, so they can reenter society after paying their debt to society. And it also says to use the least amount of our limited public resources to accomplish those goals. And most importantly, and what we're going to talk about specifically tonight, it says similarly situated offenders are to be treated with similar sentences, regardless of irrelevant factors like the color of their skin or their socioeconomic place in society. But I'm here to tell you that the law and the lack of data, we are programmed to produce it. And unless we fix it, it's going to continue down this route. This notion that judges aren't supposed to be political has been recognized since the founding of our country. Here's President Andrew Jackson saying, you know, when we put the Bill of Rights into the federal Constitution, that's the floor that protects rights that we kept to ourselves when we ceded power to our government to govern us. Okay, the power to be free of unreasonable searches and seizures, the power to be not to incriminate yourself. The government, the crown jewel of our criminal justice system, is supposed to be the fact that if they accuse you of a crime, the onus is on the government to prove that you are truly guilty of what they've charged you with beyond a reasonable doubt. It's not the other way around, like in some other countries. If the government accuses you, it's your job to prove that you're not guilty of it. This is supposed to be the crown jewel of the American justice system. And what Andrew Jackson is saying in this quote is these rights that exist, that we retain amongst ourselves, our freedoms in the United States of America. Those words that codify those freedoms are meaningless unless you have an independent judiciary that exists and will protect those rights when the government infringes upon them. You know, a big misconception about the judiciary, I think the press is somewhat responsible for this, because when they write about articles, they say if it's a bipartisan decision from the Supreme Court, they'll say the Chief Justice Republican sided with the court's 3 Democrats. Well, that's accurate, but it's not true in how we decide our cases. Each of us are independent. We don't barter like you do in the legislature, where you compromise. I've got this bill. If you support me on my bill, you might not be really into it, but if you support me, I'll support you on that bill. That kind of horse trading doesn't take place. You know, we may have differences of opinion. We might say to a fellow justice, hey, can you tone down the rhetoric in your opinion? And then I could join it. If it's just a matter of style, that might take place, but we don't trade our principles once we've decided a case. And if we believe that the law is how it applies in a particular case. And that's the way it should be. One of the most important things as a judge, this is a sign that hangs outside our conference wall. Yeah, once we vote on a case in the conference room, it says nothing we say is carved in stone. And why is that? It's because when if you're in a dissent and the majority gets circulated, you should always keep an open mind that maybe you are not correct in your position. And if you're persuaded that the majority is correct, you might join them. Likewise, if you write a dissent that's powerful enough, you might gain a fellow jurist, and it has nothing to do with Democrat or Republican parties. It just has to way it's the way that men and women jurists on the Supreme Court vote. If you looked at the data, over 65% of the cases that come before us that don't get reported in the press, most of the time we're voting 7-0 because the law is absolutely clear. But men and women jurists, in trying to interpret laws that are written in the English language, are going to differ, and they always have, about what a certain word means and how it applies in this particular case. But we all agree this is a sign that I walk by every time I take a seat at the Supreme Court to listen to a case. We are in bondage to the law in order to be free. That we all agree. Unfortunately, what's happened since Justice Stewart and I, and then Justice Bruner joined the court in 2020, what happened is the people in the Republican Party that control the super majority, not just a majority where a compromise can take place, a super majority that can do whatever it wants, no matter what the small number of Democrats that exist there say about it. No leverage at all. The supermajority, with no Democrats supporting this, introduced this bill, Senate Bill 80, and what they said, let's put party label not on all judges, but let's put party label on the Supreme Court of Ohio and the appellate court judges. And what they told the public was, we're trying to do this in order so people will vote for the judges who they don't know. This is good information for them to decide on who to vote for judge. When, in my opinion, it's bad information, because party labels shouldn't have anything to do with the way we vote on an issue that comes before us. But this is what they did, and it was opposed by the Ohio State Bar Association, made up of all the lawyers, including Republican lawyers and Democratic lawyers. They said this is a bad idea. Only, I believe, 7 states still retain party label in judicial elections. We're referees. You can equate us to the referees that ref a Browns-Pittsburgh game. Would you want referees calling the plays if you knew they were all Pittsburgh Steelers backers fans? That's the equivalent of what they're trying to do here. But there wasn't. Not everybody in the Republican Party, once they implemented this plan, was interested in this. In fact, there were some people that have, like, for instance, Chief Justice Kennedy. She shares a popular Irish name like I do that works well at the ballot box. And she got a lot of votes in the Democratic area because people assume Kennedy's a Democrat. And so there were people that said, well, what do we do in 2022 when she was running against Justice Bruner? What could we do to help them win? And here's some evidence of what they tried. Here's some of the games they try to play as they try to gain power. And you'll see this in this video.
Thank you, representatives, for taking on a tough issue that's frankly been around for a long time and been argued from one extreme to the other. My question is, would you be open to having the Supreme Court judges run on a partisan label except for the Chief Justice of the Supreme Court, who, since you're both lawyers, I'll get Latin on you, is viewed as primus inter pares, first among equals, who has certain administrative duties for the entire administration of not just the Supreme Court, but the entire judiciary, who solely decides all affidavits of judicial disqualification, so that we would preserve the nonpartisan stature of the chief while permitting the associate justices to be elected with a partisan identification.
Chairman Wilkins, Representative Seitz, I think it's an interesting question, and I will say I've learned quickly never to close my ears completely to anything in the legislative process, and so happy to continue that discussion. I think, consistent with our view of why we brought this bill, I think we would still view the Chief Justice as someone who runs with a party endorsement, spends partisan money, is on a partisan slate card. There will be two candidates, one from Democrats, one from the Republicans, and I think we would feel that it still warrants having that identification, but it's an interesting point of there are some different roles there. I think that the same kind of things you're talking about, though, different ideologies might lead to different results in some of those outcomes, and that might be worthwhile information for voters to have, but certainly open to all discussion.
Did you see how uncomfortable he was trying to answer that question? Because that's a sponsor of the bill. He's trying to say, hey, how are we going to tell the public that this is about transparency and eliminating voter fall off in judicial elections if we make one person nonpartisan? This is what they were trying to do. They're trying to secure power. And interesting what he said might lead to different outcomes. That's what they are trying to look for. They're looking for judges who will interpret the law to get to the outcomes that they want, even if the law isn't, if they're not correct on that. And this man, lifelong Republican, former justice on the Ohio Supreme Court, Paul Piper, went down on behalf of the Ohio Judicial Conference to try to stop this politicization of the judiciary, and it fell on deaf ears. But he represents all the judges in the state, whether they're supported by Republicans or Democrats. And you'll hear him say, my members want to know why you're doing this. He's speaking on behalf of one of the co-equal branches of government, and he's saying, why are you doing this? I'm going to call you on it, and we know exactly why you're doing it. And this is what he says.
My members ask why, what's motivating this? And I think it's pretty clear that the sponsors didn't suddenly wake up one morning and say, my God, we've got to do something about roll-off in judicial elections. There's something else going on here. And let's get right down to what that is. In the last two go-rounds on Supreme Court races, Democrats prevailed in 3 out of the 4. And the Republicans that run the state headquarters are embarrassed by that. So they're looking around saying, well, what can we do to improve it? And they've come up with the idea that putting party labels would improve their chances.
This opposition fell on deaf ears. And unfortunately, the same powers that wanted to politicize the judiciary, they don't want to stop what I think would be the most needed reform in our criminal justice system. And that is the lack of data that leads directly to disparity. And so I'm going to show you real quick how this happened. This picture represents what has happened to our criminal code since the 1980s. Back in 1980s, all the crimes that the state government could charge you with were contained in that one book on the left. Don't rob people, don't rape people, don't kill people, don't steal from people. They were all in there. This is what has become of the criminal code since then. Some people refer to this as hyper legislation. what I refer to it is leverage. It gives the prosecutor gives them enormous power to take any given set of factual situation and charge numerous crimes. And if those crimes are result in convictions and they stand on their own two legs with different factual basis, judges have enormous power to sentence under all these laws that have been created. Some of our mandatory gun specifications that take discretion away from judges, that send people away for 3 years or 1 year. So this is tremendous leverage. Leverage to do what? Leverage to make people enter plea agreements. 97% of all cases in our Ohio criminal justice system don't go to trial, even though I called myself a trial court judge for 14 years and I tried my share of cases, but nothing compared to overseeing. Most of my time on my criminal docket was made up of taking pleas and then sentencing people, because that's how many cases get pled. Here's a list of how many people are indicted in Cuyahoga County since 2018, and it's pretty much the same with a little dip in 2020 from due to COVID. But here in 2023, 10,927 people were indicted on felony charges in Cuyahoga County alone. That has 34 judges, the largest trial court in the state of Ohio. Out of 11,000 cases, you know how many went to a jury trial? 234. That's all. 234, and 98 got tried in front of the judge at what's known as a bench trial. So here's what I want to tell your viewers right now that every practitioner knows in the system. We tell our people that you can't get punished by exercising your constitutional right to go to trial if you're charged with a crime. That is what I call the big myth, because you absolutely can be punished with more severe crimes if you choose to exercise your constitutional right. So the leverage has gotten so great in some cases that an innocent person would be a fool not to take a plea. And we could prove this by just simply getting the data. If you made a public records request and asked how many cases were indicted as the most serious felony of the first degree, came into the system with those kinds of accusations, but were resolved by allowing the defendant to plead to a low-level felony, F4, F5, or even a misdemeanor, you could see directly with that data how many people get charged. And this leads directly to what I call the culture of plea and release. If you overcharge someone with a felony of the first degree and the bond gets set according to what the charge is, and that most people, if they can't afford the bond, they sit there and wait. And what happens? The information about the allegation gets exchanged between the prosecutor and the defense lawyer, and it could take up to a month as you move towards a trial date. And if they're able to see that it's clearly overcharged, what'll happen is the defense lawyer will walk in to the jail cell and say, "Hey, great news. I just talked to the judge in the back. The prosecutor is going to agree to drop the felony 1 to a misdemeanor. And if you take the plea, you get out today." Well, let's say that the defendant has a defense and wants to exercise his or her constitutional right to go to trial and says, "I want my trial." Well, the response is going to be, "You can do that, but you have to stay here for about another month. And I can't guarantee your trial date will go ahead then. Or you can walk out with me right now, take that plea, and the judge is going to give you probation, or the judge might give you something even sweeter, like a time served." That is the culture of plea and release that moves the system. But with the lack of data, and I'm going to refer back to that law that says you are to treat similarly situated defendants with similar sentences. Proportionality has gone out the window. It does not exist. The idea that the punishment should fit the crime. And I'm going to show you two examples, glaring examples. This guy was convicted of sexually abusing an 11-year-old boy. You know what his prison sentence was? 6 months in prison. Then I'm going to contrast this with this woman named Susan Gwynn. This was the very first case I heard as a Supreme Court justice on review. Ms. Gwynn was charged. She was charged after she was caught going into various senior citizen homes, dressing in scrubs as if she worked there, and taking items of property from the elderly victims that live there. Not behavior that we condone in our society, right? She had no record, but she was taking a lot of items that traditional thieves don't take for resale value on the street. She was taking family pictures, trinkets, odd items, and she was hoarding them in various boxes in her house. These facts, as a former mental health court judge, kind of struck me as an alarm bell that Ms. Gwynn may be suffering from a mental illness. But she was charged with some 35 felony burglary charge. She received that lawyer right there, sitting next to her on the left. And they negotiated a plea where half the charges would be dropped in exchange for her plea to 17 counts. At her plea hearing, the prosecutor was silent as to what they intended to advocate for at sentencing. Silent, didn't say anything. And the judge went over everything that could possibly happen. He said, I can sentence you concurrently. That means all your charges alongside each other. So when you're done with the longest one, you're done with all of them, or consecutively. I can stack them on top of each other. Several times he said, if I give you prison, I may give you probation. If I give you probation, you will have to pay restitution for any of the items that we did not receive. Do you understand this, Ms. Gwynn? She was asked. Yes. She enters the plea and she shows up. 30 days later at her sentencing hearing, the prosecutor for the very first time says, Your Honor, we're asking for 42 years in prison. The defense lawyer to her left says, Your Honor, we're asking for probation and she wants to make restitution. And the judge said, you're both wrong. And she gets 65 years in prison. So she found out on her sentencing date, she wasn't going home as she hoped. And as her lawyer argued, she found out she was going to die in prison because she'd have to reach the age of 120 to resolve her, pay her debt to society. And unlike certain murderers and rapists who get convicted in our Ohio system, who get parole dates, she doesn't have the opportunity for parole. That has been denied her. And this is the state. This is why I wrote the article called the guardrails are off. There are no guardrails. So what guardrails are intended to represent what a judge's discretion is. And let me give you an example of a small amount of discretion on a low-level felony. A felony of the 5th degree is punishable by 6 months in jail, 6 to 1 year. Those are the guardrails, okay? Now, judges can decide in monthly increments based on what they hear at a sentencing hearing, what to sentence. They can sentence 6, 7, 8, 9, 10, 11, 12. Those are the guardrails for a felony of the 5th degree. So you're listening to the defense lawyer who's asking for the lowest amount. You're listening to the prosecutor who may be asking for the most severe sentence. And then the judge picks one of those months based on that argument and imposes it. How does the judge, how do they do their thinking? How do they pick 7 months versus 11 months versus 9 months? Well, there's no science to it. They use their gut. That's what I did for 14 years because I didn't have any data that said similarly situated people do that. Now imagine you take the guardrails and put for a case like what Susan Gwynn had. That single judge had the had the guardrails where he could have sent her to probation all the way up to 150 years, and he picked 65. How did he pick 65? The same way I would pick 7 months or 6 months, using my gut and my mood that day. He didn't have any data, and so here she sits in Marysville, and she and the jurists on my court see nothing wrong with that. That's what the legislature said, and that's what she got. But here is the most important story that has been written about the broken Ohio criminal justice system since 1996, when our sentencing laws were implemented. And it was on cleveland.com. You may have read about it. And it wasn't a deep data dive. It just happened to be a reporter who happened to be in the right place at the right time and cover within a 24-hour period 2 sentencing hearings. You'll see the woman, Ms. Bosworth, on the left. You'll notice she's white. She was convicted of stealing $250,000 from the Chagrin Falls school system. She received probation. 24 hours later, the reporter, Corey Schaefer, went to the sentencing hearing of Ms. Hopkins. You'll notice that she's African-American. Same crime, but she only stole $42,000 from the Maple High School system. But she received 18 months from the judge. Why is this? Because judges don't have information to keep themselves consistent or consistent with the other judges and comply with that mandate that says similarly situated defendants should receive similar sentences. It's not the judge's fault. This is programmed to do it. They are powerless until we collect data to do anything about this. The day after that story ran, I was quoted in it. And let me tell you how popular that story was, because Cleveland.com stories usually have a shelf life of about 4 hours, maybe a little longer if it's a Browns story about the Browns. But I'll tell you what, that ran for 5 days because it was being tweeted and retweeted, not only through Cleveland, but through Ohio, through the United States of America, and internationally. Like, what is wrong? And I received a call from our Republican Attorney General David Yost. He saw how this threatened public confidence in our court system, and he recognized that judges don't know what other judges are doing with similarly situated defendants and with their own past sentences. And he said, "What can we do?" And I said, "Well, let's get behind this database." As Jerry mentioned at the beginning, with the late great Ray Hedden, I wrote an article in Cleveland.com. You can still Google it. And we said, let's get a centralized database so judges can keep our sentencing. I also wrote one with Judge Bergeron from Cincinnati in the Atlantic, and I've been trying to bang the drums on this forever. And we had such momentum going that the Ohio legislature was about to pass a law, Senate Bill number 288, that mandated that this sentencing database be created. You'll see the language there on the left that requires it. But interestingly, after the court changed hands in 2022, after they put party label on the judiciary, 3 weeks after that election, it was taken out, and the press didn't even report it. And I said, why would policymakers take out an opportunity to collect information about decisions they make over people's lives and spend on our prison system and our criminal justice system that estimated $4 billion in taxpayer money every year? So I dug in and I found the moment it happened. The press didn't show you, but I'm going to show you right when it happened.
This amendment removes the provision in the bill related to the state's criminal sentencing commission database pilot program. There was fear that this could create some unintended consequences that was not necessary to be put in the bill. The program will continue as is. Any questions or comments?
Mr. Chairman.
Ranking Member Thomas.
Thank you. The concern I have with this particular amendment, the state currently does not keep accurate or complete statewide data regarding criminal offenses and sentencing. a program to create a statewide criminal sentencing database seems to be a worthy project for the Sentencing Commission to undertake. I think we should keep this bill, and I'm going to object to the amendment. Just to be more specific, the database, as we discussed during the committee, during the process of looking at this whole issue, the database was critical. Collecting the data on a number of areas related to the criminal justice system. To remove that, it just makes no sense. And I would like to know what unintended consequences are we talking about when we had every opportunity to talk about all of those unintended consequences during the discussion process.
Yes, thank you, Ranking Member Thomas. This amendment was added just the last hearing, and I believe you serve on the committee with me. The work is being done right now by the Sentencing Commission, and this amendment was unnecessary in the code. And with many of these amendments, we were negotiating with opponents of the bill that are now neutral, and this was a concern. So we felt that it was in the best interest to move the bill forward to remove this from the bill altogether. Any other questions? We do have an objection. If no other questions, can the clerk call the roll?
And just like that, they took that opportunity out of the bill. And here's the questions I have. Why would policymakers remove a mandate to collect information about this overwhelmingly expensive system that incarcerates 50,000 men and women in our state? There was fear that this could create some unintended consequences. The senator asked, what are those consequences? He didn't answer his question. With many of these amendments, we were negotiating with opponents of the bill who are now neutral. Who are the opponents that are now neutral? He didn't answer that question. The work is being done by the Sentencing Commission. Is that true? No. I can tell you that they did not renew the contract that we had for the University of Cincinnati that was doing pilot programs. That has not been renewed. The Sentencing Commission is not moving forward with data-driven sentencing at this time. And I'm going to conclude this presentation with another snippet of information by the truth teller here, Paul Piper, who represents the judges. And it was at the same hearing, but it relates to sentencing, and I want you to hear it.
I know in a place like Cuyahoga County where you have 34 family police judges, the conversation that a lawyer might have with a client is not, is the judge a Republican or a Democrat? It is, how much of a hanging judge? How difficult is this judge on criminal defendants? And there's a range. But the notion that criminal justice is applied differently between Democrat and Republican judges just doesn't cut it at all.
And if you want to see proof of the truth of what he just said, I'm going to show you something that I never thought I would have on video. For 2 weeks of the year, every year, I serve in the arraignment room in Cuyahoga County, where the room is filled with people who have been indicted on felony charges. And they come up, and the process is to, if you're lucky enough to have a lawyer, you come up with your lawyer. If you can't afford a lawyer, one will be appointed for you. And that's where we ask, how do you plead? And 99.9% of the time, they're going to plead not guilty. And enter a plea of not guilty. Bond will be set at that hearing, and then they will roll. They will they will roll the computer from one of the 34 judges. And I used to see there used to be 5 or 6 judges. When their names were called, you could see a visceral reaction from the lawyers and the insiders who knew about the meaning, because it was like a roulette wheel, and the feeling was, your outcome has just been determined. Now, in this video, I mute the name of the judge. And why do I do that? Because I don't want to make this personal against those 5 judges. This is systemic. This is the problem with data. Once this judge is gone, they'll be replaced with another one. There's no control on, unlimited discretion with no guardrails containing that discretion. But you're going to see it. Watch the first, number one, watch the reaction of the lawyer when the judge is assigned, and then look at the face of the defendant, who has no idea why people are reacting and the way that they do in this. And you will be amazed at watching this, that takes place every single day in that arraignment room down in Cuyahoga County.
Present in the courtroom, do you want to waive the reading of the rights for your clients?
That's correct, yes.
The rest of them are waived. What about you guys? All the attorneys?
Yeah.
Okay, there you go. How's that? All right, great. Okay, Mr. Kersey.
Judge, thank you. We'll acknowledge kind of receiving that. We'll waive the reading of it and waive any defects in time, manner, method of service and are not building a task force to adopt with the bond recommended by the bond.
All right, plea of not guilty is entered on your behalf. Your bond is set at $5,000 personal. They need a DNA specimen. Judge is your judge.
5-year-old.
Okay, 11:29 at 9 o'clock. All right, okay.
Thank you.
Yeah.
Judge, good
All
to
right.
see you.
Nice to see you.
We have stuff on.
All right, have a good day.
And that is the status quo of Ohio sentencing. And I have challenged any judge or justice in the state that disagrees with me to meet me at the city club or the forum of their choice. And I will debate them on this. And the people can hear for themselves that that is not the status quo of what took place. So would love to open it up for questions and discussion at this time.
Okay, fellas, if you have any questions, go ahead, have at it.
Let me take a couple of deep breaths first on this. I'm not surprised, because I do presentations in regards to the prison pipeline. But to see the data just make it so much more clear how systemic this issue is. I guess my question for you, Judge, is the one thing that went through my mind is, do this type of judgment have anything to do with the promising of bed space in the private prisons? What?
Yeah, I mean, that's something that is worth exploring. But again, we don't have the data. Can we prove that people are directly sending people to private prisons that they normally would not in order to fill bed space? If we collected data, we could look and analyze that very question. What really got me thinking about this, if your listeners Google Florida's broken sentencing laws, there were some investigative reporters down there who did the exact same thing that we should and the Marshall Project should be doing, and that is collecting data and showing the disparity that exists from courtroom to courtroom. And they found unbelievable accounts of disparity. They found a African-American defendant who had been charged with aggravated robbery and had one misdemeanor in his background, and a white defendant who had been charged with aggravated robbery and one misdemeanor. So on paper, they looked the same, but the African-American defendant received a 25-year sentence, and the white defendant received two years local jail time. And when they reported these facts, people were outraged, and the legislature responded and said, we got to do something about this to because it doesn't make any sense. It's unfair. And if people are going to lose confidence. And so Florida started in this effort to collect data, and that they are now leading the nations. The federal system, they have this data, and they have guidelines to keep judges' discretion in check, so you don't have this disparity where you can walk into one courtroom with one set of facts, same lawyers, and get an outcome like probation. And then you could take those same lawyers, same facts, walk 15 feet across the hall, do it again in front of another judge and get 20 years, 30 years, or 40 years. That's how crazy and how sentencing is all over the place in the state of Ohio. And that goes for the unbelievably lenient sentences that are unexplainable, like that sex offender that received a 6-month sentence, to the 65-year sentence for a property crime. And we got to do something about it.
Judge, if I could piggyback on what Brother Albert Earl said. I know you said we have to get data, but is it true that the legislature puts in the legislation promising those who could build private prisons a certain occupancy rate? That right there seems like there's a conflict of interest, and especially when you combine it with the fact that it's a for-profit venture. So it would seem to me that the fact that they've put it in the legislation in and of itself would make us take pause.
Right. I mean, when you look at if they incentivize with private prisons, that's a policy that we have to question. Why would we incentivize putting people in prison that didn't belong there? We should be looking for safety valves on the prison system that do not exist. The prison system isn't called the Ohio prison system. It's called the Ohio Department of Rehabilitation and Correction, right? So that means that nonviolent people that don't pose a threat to the community should have a safety valve that once they go in and demonstrate that they've been rehabilitated, they should be able to have a pipeline to be released and re-entered into the community. They got rid of that in 1996. They moved the parole board to the end of the sentence, no matter how well you behaved, or conversely, how bad you behaved, you both got out on the same day, and the parole board was supposed to supervise you in post release control, is what they call it. But they got rid of the parole board, so it doesn't make any sense from a policy point of view. Why do you keep people there longer than they need to be there after they've paid their debt to society? But that's what the system, that's the status quo right now.
You're on mute, Brother Jerry.
I said, Brother Darren, did you have any questions? Hold on, before we go there, let me ask one question from the audience.
Sure.
Can the bill to collect data be reintroduced to the Ohio Senate? If so, who does that introduction? That was asked by Maurice Morris.
I've met a number of people while out on the campaign trail that have promised that they want it. I think this should be reintroduced, and we should fill that assembly and ask them the questions that legislator did not answer. I mean, why would you dispense with an opportunity to collect data? I mean, every other single industry and profession is now becoming more and more data driven, right? I mean, the medical, would you rather be treated for an ailment by a doctor who retired 10 years ago, or would you want to be treated by a doctor who's up on all the latest information that helps them make the decisions that they need to make to treat you? Why wouldn't we do the same thing when we're dealing with lives of people and public safety and rehabilitation and law and order? Why wouldn't we be moving in the same direction?
So I'm sorry.
Go ahead, bro.
So what would you recommend that we do from the community in order to make sure that this is put back on the table?
So every single new judge that, or someone running for judge who comes before you for your support and your endorsement, I believe this should be the first question asked. Do you support data and data collection? Because and if you don't, I want to hear why not. I told Jerry this story of that I documented in one of my writings. I went down to the law school, and all those young kids who have grown up with data, they understand this. They're going to be soon to be lawyers. But I was glad that they heard an opposing voice. It was a trial court judge, and he's a friend of mine. But he went down and spoke to them 2 weeks later to give the opposing view. And they said, "What's the argument against that?" He said, "I heard Donnelly was down here talking about data. I totally disagree with him." And they said, "Why?" So he went up to the chalkboard and he drew a football field goal post. And he said, "This is my discretion on a felony of the first degree." And on one end, he put 3 years, which is the minimum. And then on the other was 11 years at the end. He goes, "The law says that my discretion is as long as I kick the football in between there, that's it. End of story. That's my discretion. That's how I decide. That's what the legislature has said about my discretion." Donnelly apparently wants everybody to get 3. And one of the students said, "No, that's not what he said. What he said was that if you've given similarly situated defendants 3 in the past, and the other judges have 2, you can still go to 11, but you got to say why. You got to say why." And, he had no answer to that. And so, if we had data at sentencing, people would have data at their fingertips and have sentencing memorandums and say, "Judge, this is what similarly situated defendants have received. Here's some of your own cases. And I want to remind you of your obligation under the law, under Ohio Revised Code 292911, to treat similarly situated defendants with similar sentences." And if that's done on the record, that's powerful information. Because if a judge can't distinguish or articulate why he's treating the defendant differently than someone he has done in the past, then they're not going to do it. That's the power of data.
One of the things that I wanted to state is really more of a statement than a question. A few years ago, when we started GPAC, and our president is Reverend Ben Goldston, aka Rabbi. We began our first question, one of our first questions to everybody, and we asked them to put it in writing. Every judicial candidate that comes before us is, do you agree to giving us or giving the public access to your sentencing data? And when we began to ask that, we knew full well that it was a difficult process to get access to that data, but we wanted to begin the process of actually asking that question and getting them to agree to it in writing prior to them getting on the bench, if that makes any kind of sense to you. And one of the things, I guess the question that I would ask you, Justice Donnelly, is do you think that everybody who has judicial candidates, regardless of what court it is that comes before them prior to and while they're running, should ask that question, do you agree to give us access to your sentencing data?
Yes. Yeah. I think we serve at the pleasure of the public, and the public has every right to know everything about our decisions. And if we're doing things in the justice system that we don't want them to know about, or we can't justify, then we probably shouldn't be doing it. And that's what I've always said about transparency, that we should be providing full access to our court records and our sentencing data. ODRC is sitting on a gold mine of data that would tell us a lot. When a judge makes a judgment call about whether to sentence someone concurrently, that means alongside each other, or consecutively, stacking those sentences as I described in my presentation. All they have to do is make the subjective call on any given case and say the magic language or in the statute. I believe that consecutive sentencing is necessary to protect the public. As long as they say those words, they are completely insulated from any type of review at the Court of Appeals. And they can stack those on, and the person's powerless to do anything about it. Okay, and that's all they have to do is say the magic words. So if that judge is in a bad mood that day, and says, you know, I think you're a danger to the public. Doesn't matter if there's a presumption in favor of probation. They can stack those charges on top of each other to as far as the legislature will allow them.
Wow.
Okay. We have a question from the audience. It says, even with data, will that remedy implicit bias?
Yes, it will, because I think what it will do is force the legislature to bring the discretionary walls that exist that are so wide. I mean, there is no other powerful actor than a common pleas general division judge in the Ohio government with regards to the people and the lives that are before that person. There's no one. If you have discretionary guardrails that start with probation, and a man or a woman stands before you and you have the power to either give probation or 150 years on any given case, that's extreme. That's the fertile ground for implicit bias, right? Like, we can't control our biases. Every human being has them. But if you had data that informed the decision maker, that how they've treated them in the past and how other judges have done it, the system will self-correct, and we will eliminate, at least to the extent possible, within reasonable boundaries, the problem of implicit and explicit bias.
Did y'all have any other questions? I have, go ahead. Go ahead.
I do, but I was trying, I wanted to give Darren a chance to ask his.
He said he didn't want to ask any right this second.
Oh, okay. So how many states would you say have the same issue?
I think the vast majority of it. But Ohio, we've known since 2008 the problems with Ohio. The National Center for the State Courts that studies jurisdictions, they did a study in 2008 of 23 states, all of which have sentencing commissions that are supposed to make sure that our sentencing policies are fair and treating people fairly. And they did this study of how many guardrails exist in order to keep judges' sentences proportional and consistent with each other. And out of all the 23 states that were ranked, Ohio and Wisconsin fell the last because there's no checks on the system. There's no guardrails that exist, and discretion is all over the place.
Wow.
They rank the worst in it, tied with Wisconsin.
Let me ask this question. This issue you shared with us, and the assumption is that this affects Black and brown and minority communities, but how does this affect the poor white community as well? Is it comparable?
Yeah, I think it's absolutely comparable. It's about power. If you in a system without data, right now, if you have power or you have wealth and you hire the right attorney, and that attorney knows the judge, or that attorney has a good relationship with the prosecutor, you can get a better outcome in this system. And I've been one of the most vocal advocates against factually baseless pleas in the system. That's when an accusation like rape, that usually happens in felony court in sexual assault cases. Someone will be charged with rape, or some other form of sexual assault, and they'll go in the back room, and if the judge is willing, the prosecutor and the judge will allow that defendant to plead to a crime that has nothing to do with rape, that a jury could never produce that outcome, okay? And they come out and they plead rape to a crime known as aggravated assault. It has nothing, a jury has never reached that decision. In fact, if a jury came back and said, hey, Your Honor, we've been thinking about whether the state proved these charges true. We really don't think it's a rape, it's an aggravated assault. Everybody would look at the jury like they're crazy, because everybody knows that crime has nothing to do with it. But yet if you go in the back room and you have power, you can get a plea to something that you did not do in order to resolve the case. That's what's going on in the system on a daily basis. And if we had data, we could stop it.
But you would agree that the disproportionate sentences is mostly with African American males. Am I correct in thinking that?
Yeah, I think of the data studies that I have seen, that there's evidence to prove that. I mean, there's evidence to prove that if you are, let's take death penalty cases. If you are charged, your chances of getting, if the defendant is African American and the victim is white, they are more likely to be charged with a death penalty case than if the defendant is African American and the victim is African American. That's, the discretion is all over the place in terms of how that gets carried
That's an
out.
interesting way to look at it. And it's just an interesting way to look at it, because I know that the court system does a very good job, and it's not Democrat or Republican. It's all the court systems do a very good job at hiding the data. And maybe some of the things that we can look at is the disproportionate sentencing of the death penalty as a benchmark, because we can't get individual judges' data right now.
Oh, that's something that we could gather right now, because we have 88 counties, and your chances of getting charged with the death penalty are not so much tied to the facts of your individual case. It's more likely where the crime is committed, because they only charge it in the communities where they have the funds in order to carry it, because they're so expensive. There's horrible crimes, and I've collected data on this, that have happened in rural counties, and they don't even consider charging with the death penalty, because the county would go broke if they prosecute it, because they don't have the resources to do it. So your chances of getting charged with a capital crime are tied directly to where it takes place. And you can prove it. That's not my opinion. You can prove it with data. You can prove it with data.
So in the urban core, where they have a much larger budget, that's part of the reason why. And that just so happens to be where the vast majority of people of color and minorities live.
Right.
Okay, interesting.
Just one more question. Oh my goodness. Say I wanted to look up sentencings that dealt with child abuse cases. Is there any type of resource that will point me to, you shaking your head? So that's what you mean by data.
Right. It doesn't exist. The Ohio Sentencing Commission put out an article that you can Google. It's called if you Google Ohio Sentencing Commission, the data disconnect, it outlines exactly what we don't know about our system. And it's information that most people would believe we have to have in order to function properly, but we don't have it. We don't know how many people are on probation in this state. All this data that we spend countless taxpayer dollars on, we don't know that. We don't have it.
That's unbelievable.
Yeah. This is
unbelievable.
Mind blowing.
Wow.
So
we have one, and I'm a real big proponent of never hiding any candidate that I deal with. And we have one question that's totally unrelated to this uh, subject matter. Uh, and if you would be so gracious as to answer it for us, Justice Donnelly. They said, Justice Donnelly, unrelated to the subject matter, how do you feel about ending qualified immunity for law enforcement officers?
Oh,
You know, that's a policy issue, and that could possibly come before me as a
So you
justice.
can't answer?
Yeah, and so we're prohibited from commenting on that because that could be an issue on that. But it's something that should be debated.
Okay. All righty. So we went actually a little bit over our time, but it was, did you have another one, Russ?
yeah, totally unrelated. But what a question that's baffled me, Justice Donnelly, since the state Supreme Court found the way we fund public education in the state of Ohio unconstitutional, and the
Yeah,
state legislature's like, so what
yeah,
can be done?
that's a question I get asked quite frequently, and I was asked during the redistricting debacle of 2022, like what do you do when a redistricting commission doesn't follow a court's orders to redraw the maps proportionally as required? And I tell people, this goes back to the very subject at the beginning. We talked about the rule of law. We don't have an army at the Ohio Supreme Court. We expect that people, even the people that disagree with our decisions, that they are to be carried out. And if the people that directly disobey court orders and they are in positions of power, the only way to deal with them is to vote them out.
Absolutely.
Okay. Here is the absolute last question throw it to the audience. Sister Sheila Smith. Her question is how do you advocate for sentencing data? Is there anything in the Constitution to address this?
Well, the best way is through the legislature, because our former Chief Justice Maureen O'Connor, who I'm very good friends with, she was very supportive of this. She thought it was the most important thing she wanted to see come to her fruition. The one thing we disagreed with, I think she believed that she could convince the judges to volunteer because this idea made the most sense. But I am convinced, having been a judge, that because judges understand one thing, and that's when the law says you shall do this, not you may at your discretion, you shall do this. So I think the only way to get this done is to move towards a unified court system, have 88 counties use the same sentencing entry so we collect the same data points, and we move towards mass collection of this data. And it's going to take an act of the legislature to do it. So in order to do that, we need to build up political will. We have to have public debates on this. Every single person that comes to your community and asks for your support should be asked this as the number one question. Do you support it? And if not, let's hear why. Let's hear your response why.
Love that.
Absolutely.
Love that. Right. Absolutely. That's holding them accountable. Do you support sentencing data? And if you don't, why? Every single judge that comes before us, and really every legislator that comes before us as well.
Right. And it's interesting that people that don't want it, if they get caught by the press and they ask, they don't have an answer. They'll say things like, well, every case is different. Every case is different. Yeah, that's true. Every case is different. There's different factors, but there's no difference that can explain a 25-year sentence for a black defendant and a probation for a white defendant. you know, I don't care what the facts are. If it's the same crime, that does not, just simply saying every case is different is not sufficient.
Absolutely. Well, Justice Michael P. Donnelly, want to say thank you for taking the time. I want to say to the audience, we're asking you to reach out to anybody and everybody, the ministerial alliances, the Divine Nine, the Prince Hall Masons, to the National Congress of Black Women, anybody who wants to have a comparable discussion with Justice Donnelly, reach out to him at Mike Donnelly, that's DONNELLY at me.com. That's Mike Donnelly at me.com, because he's willing to go ahead and have a conversation with everybody. We want to get him out there because this is extremely important information. This is a lot. He's given us a lot of jewels that we can take and actually use to hold people accountable, regardless of who they are, but just to hold them accountable so that we can make this system just for all, not just us, if that makes any kind of sense to you. So any last words to the panel?
Just thank you.
Yeah,
Thank you very much.
Thank you very much.
very informative. Very
Thank you. Thank you. Very, very
Right.
informative.
Thank you.
I'll piggyback on that, and I really appreciate you. I look forward to having more dialogue with you.
Thank you.
And for all the people who are watching, you'll get a link of this. We're downloading it and we're sending it to Russ. I have a link, or Albert will have a link, and Darren will have a link, and we can put it on our social, or we'll put it on our YouTube channels as well, so it'll be easy to distribute. And you know, my team will chop it up and so that we can put it in bite-sized pieces. So I thank you, Justice Donnelly. I thank you to the panel, and looking forward to sharing this information to our community, and good luck on your run for Ohio Supreme Court Justice.
Thank you very much.
Hear, hear.
Good luck.
Good luck.
Have a great night.
Have a good one, Jim.
Bye.
Well, everyone who had the opportunity to attend or watch the Justice for All presentation by Justice Donnelly, the information, I'm gonna be very honest, it was just simply overwhelming. And it speaks so much to what we see in terms of the prison to school pipeline, and the unfair sentencing when it comes to uh, people of color and poor people. And I mean, as a community, as citizens, we have to demand that our legislator put that back into law, that the data must be collected in order for these judges to be able to follow a guideline, a proper guideline of sentencing with our people. I mean, and when I say our people, I'm not just talking about black people. I'm talking about people, period. I mean, some the cases that he showed is just, I mean, a couple of them just literally knocked the breath out of me, man. I'm still stunned at this point right now. Because it's one thing when you know, it's one thing when you think you know, but it's a whole nother ball game when there is something that you don't know that comes and support every thought you ever had about a system. And this stuff is systematic. It needs to change. And man, we gotta do some work. I'm gonna say this. We got a lot of stuff going on, especially out there in social media land about I see a lot of people having debates and arguments over stuff that, to me, and it's just my opinion, that's just, it's not even worth a breath to even be arguing over. We have some very, very, very serious issues going on behind the scene. What I like to call it is the undercurrent of what's going on. The troubling in the water that none of us feel until this stuff change into a tsunami, man. And we beyond really, to be honest with you, we beyond a tsunami right now. When you think about the millions of men that was unfairly sentenced across this nation, right here in this city, right here in this state, when you think about the millions of women that have been unfair sentenced to years without any data to hold judges accountable, and they're moving at their discretion. And if people have bias, if people is racist, if they belong to groups that we don't know about, man, with the amount of money that's being exchanged within the state and the private prison level and federal level, the work that prisoners do, with the amount of money that's being exchanged, you already know there's potential for bias. And there's potential for someone to be doing an absorbent amount of time and just to be able to push out product for pennies on the dollar. It's slavery again. It is truly slavery. It's really convict leasing, which was supposed to have been outlawed back in 1941, 42, somewhere around there. But it's basically a convict leasing all over again. And I asked the judge that question. Did he think it was did he think that a lot of this had to do with the promise of filling prison beds? And he said, he would think that the data would support that. Do they have any evidence of it right now? No, but if the data was in place, the data could support the thought of that. But we know, just based on the sentencing, the unfair sentencing, that is something that is very, very wrong with our criminal justice system. So when they talk about criminal justice reform, it's just not about being reformed from the standpoint of releasing men from prison, releasing just black men, releasing poor people. Man, this affect the entire nation. When you talk about poor white, poor Latino, blacks, black men in particular, black women, poor white women, people with mental health, people who are mentally challenged, people who have cognitive issues, those who we would say is our special need, who have special needs. When you look at the amount of people that have been sentenced that have issues like that, as well as what we just talked about, man, we got to do some serious work. I'm gonna follow up with Justice Donnelly. Of course, I'm gonna do a lot of follow up with the men that was on the panel. We are connected now, and we're gonna be doing more collective work via our platforms, our social media platforms, because there's a lot of information that we want to get out to the black community that we feel is extremely important. And by getting it out to the black community, it will get out to other communities because we're sharing this information on all of our social media platforms. So I'm really looking forward at this point into getting more information and seeing how I can affect change and making sure that there be some change in policy to make sure that the data becomes important, an important part of the sentencing, so that moving forward, men and women can be sentenced fairly. So, hey, I want to thank everybody who did tune in. If you didn't have an opportunity to tune in, the show was recorded. We will be putting it on our platforms. Be looking for it. I'm definitely going to tag everyone when the recording is sent back out to us, and we're going to make sure that all of our audiences get to it. But when you receive this share, man, please make sure you like, share, subscribe to the channel, of course, but more importantly, with this information, whether you subscribe to my channel or not, I'm more concerned about us sharing the information. Get this information out to people so that we can have dialogue and start holding people accountable, and those who don't want to do what the citizens need them to do, we're gonna exercise our vote and get them up out of there. Just like Donnelly said, whenever somebody come in your town uh, campaigning on anything, ask them all, do they support the data? Do they support getting data within our court systems? And if they not, and if they don't know, and if they're not, then the next question is why? And we'll know what to do from that point. So thanks again for everybody who tuned in. Look forward to this being put out on the other platform soon. And thank you for tuning in, and thank you for sharing your questions to the audience that was a part of the panel. And listen, this is counterintelligence. Please make sure that you like, share, and most of all, subscribe to the channel. Thank you.